Thank you so much, James, and thank you all for joining us today. I think this will be a very interesting panel, and I mean, let's just jump right into it. I would like to start. I would like to ask Jorge Cervantes to give us a brief overview of where Mexico stands today, social and politically wise. Jorge, would you care to?
Thank you very much, Rose, and thank you to my fellow panelists, James and Legal 500. Thanks for the invitation. Uh, I I will take 10 minutes of your time to give you a little bit of context on some of the social and political scenarios we are living in Mexico, so that this can provide some background for the panel of distinguished speakers that we have. And it was a little bit difficult putting together some ideas here because of the current situation, which is very much in flux. So Mexico, as you might know, it's a huge and diversified country. It has a population of more than 120 million people. It has a large economy, which is ranked among the 15 largest economies in the world based on GDP. It is a democracy. It is organized as a federal republic with 32 states, and it is governed by an executive branch headed by a president, a legislative branch, which is a Congress with two houses, a Senate and a Chamber of Deputies, and it has a federal judiciary, which is headed by the Supreme Court of Mexico, the Federal Supreme Court of Mexico. As of today, Mexico is considered as an investment grade country. It is a country with a great number of investment and tax treaties, the most of I think in the world. And as you might guess, the most important of these investment treaties is the newly renegotiated United States, Mexico, and Canada Free Trade Agreement. This agreement came into force on July 1, 2020, and it substituted NAFTA, and it is the basis for a huge and growing economy, the Mexican economy. In connection with NAFTA, Mexico is the most important and the largest trading partner of the United States. And Mexico is also one of the most important investment partners, i.e. Mexican companies invest huge amounts of money in the United States and vice versa. So the economy of Mexico is very much mixed with the largest and most powerful economy in the world, which is the American economy. In addition, Mexico has the largest border in the world with the US, and the US is the largest foreign investor in Mexico. The US investment in Mexico represents in excess of 40% of all foreign direct investment in Mexico. So this situation in and of itself makes Mexico a very attractive market for investments and for infrastructure and from M&A in general. However, the current political situation in Mexico has significantly impacted and affected many markets and created risks as well as opportunities. And that would be the context, I think, of what we will be hearing today. You have a huge opportunity because of all of these things I just explained about Mexico, but then you have a political consideration that has created risks and uncertainty, which creates opportunities which need to be analyzed. At the end of 2018, there was a federal election in Mexico, and Andres Manuel López Obrador, or AMLO, became the president of Mexico. He won a majority in a landslide election, and his party, Morena, took the majority also of the Mexican Senate, of the Chamber of Deputies, and they also have a majority of states throughout Mexico where they have a predominant role. Now, with this majority, they have taken multiple actions and decisions which have impacted key sectors of the economy and generated what I think is legal uncertainty for many projects. Among the most relevant decisions that AMLO has taken and that have had an impact on doing deals and business in Mexico in general are the cancellation of the Mexico City airport and many other important infrastructure projects, his open decision to support Pemex, which is the national oil company, and CFE, which is the national electric company, at all costs, and to attack private investors, or at least to favor Pemex and CFE in relation or vis-a-vis to the participation of foreign investors. He has attacked the energy reform that was passed in 2013 and which was one of the huge drivers of the Mexican economy for the past 5 years through the creation of laws and regulations that, in our opinion, go against the constitutional and legal framework of the energy reform. He has not struck down yet the constitutional changes to the energy reform or the federal laws, but he has done things around the energy reform which have caused significant concern and uncertainty for investors. He has attacked independent regulators and substitute people who work in these independent regulators, the Banking Commission, the Hydrocarbons Commission, the Energy Commission, the Antitrust Commission, the Electoral Agency, the Water Commission, the Gas Commission. All of these were headed by professional politicians in the past, and AMLO in the past 2 years has substituted members of these commissioners, and has put people there that, in our opinion, are not up to standards and do not have the experience and do not have the track record to belong to these commissions. He has decided to build some projects that are highly questionable, among them an airport outside of Mexico City, a refinery that's going to cost $8 to $10 billion in Tabasco, and he wants to build a train across the Yucatan Peninsula. All of these projects, which have enormous negative implications, I think, for the environment, for the economy, and in general for the way the decisions have been taken to do these projects. He has used illegal and unregulated public consultations to stop existing projects or to attack enemies. And these public consultations have generated uncertainty. So if you mix that political scenario with the COVID pandemic, which has resulted in a huge loss of life and a huge economic problem, you will see that in Mexico, there's more than 900,000 infected people and more than 90,000 deaths. And this has created also tremendous economic contraction and losses. Mexico is expected to decrease in its GDP and economy by almost 10% compared to last year, which is going to be a huge hit in comparison to many other countries. And Jose Ignacio, my partner, will speak in much more detail about it. But in the first quarter of 2020, the three rating agencies, Fitch, Moody's, and Standard & Poor's, downgraded Mexico's sovereign credit ratings and Pemex rating. Now, the sovereign rating is still above Pemex's rating, but Pemex's rating is junk status. And as I said, Jose Ignacio will go into the details. So this is the context in which we are investing today and carrying out deals. You have huge potential. You have a lot of business with the largest economy in the world. And you have this political situation that is creating uncertainty. So I would say that notwithstanding this political situation, there are, and we have seen in our firm, significant opportunities for M&A and investment in Mexico. There will be, and there is today, smart money taking advantage of these opportunities. Mexico is an open economy. It's an open, all of the areas of economic activity are open to foreign direct investment, except for very limited exceptions. So savvy and intelligent investors will continue to invest in Mexico and will take advantage of cheap pricing. They will take advantage of existing projects where they cannot continue to invest for different situations or where they want to get out because of the uncertainty. There will be others that will want to get in. Also, there's technological innovation and virtualization, which will allow us to do better M&A deals and present opportunities for experienced buyers. And also there is liquidity for private investors from prior years, which generate a very good opportunity to deploy. As I said, I see possibilities, I see it attractive, and I see also risks. And all of this taken together is the context under which we are, and we will be providing advice for M&A businesses. Thank you, Rose.
Thank you, Jorge. This is indeed very helpful. Now, moving towards Mexico's macroeconomic and investment situation, I mean, it is almost certain that Mexico will lose its investment grade during AMLO's administration, which means a lot of investors will while others who focus on high-risk markets will look to enter into the Mexican market. Jose Ignacio, what's your take on this topic?
Thank you, Rose. First of all, good morning to everyone. I'm honored to share this panel with my...
Sorry to interrupt. We're getting a bit of feedback on your microphone. I don't know if you have two connections open or if you can mute one of them. If you try speaking now, hopefully it'll be solved.
Okay, give me 1 second. Apologies.
No worries. I'll fill in the silence while you're doing that by asking Jorge a question, if I may. Look, you mentioned some of the some of the dubious appointments that the AMLO administration have made. I was reminded of a recent book by the American writer Michael Lewis. I think it's called The Fifth Risk, looking at similarly dubious appointments by the Trump administration. I mean, look, unexpectedly, Trump and Obrador seem to have a fairly close relationship. To what extent does the November election result in the US matter for Mexico's M&A landscape? I mean, is this going to impact things for Mexico to any significant extent?
Well, I think you will hear opinions on both sides. Some people say that nothing will happen, that if Trump loses, it's going to be good for the US and for Mexico and for the world. And others think that Biden will be very aggressive vis-a-vis Mexico. It's hard, I think, to predict what will happen. I think there's more damage being done by the Mexican politicians than by the American politicians on Mexico. I think the Mexican politicians will pay close attention, obviously, to who the winner of this election is. And there's already been some approaches by US politicians to AMLO and to his Secretary of Energy and to others saying, hey, we're very concerned about what you're doing. We don't like what you're doing. You're violating at least the letter and the spirit of NAFTA in the energy sector. You're precluding our companies to carry out businesses in Mexico, and we don't like that, so please don't do that. So I think we're going to get much more of that, notwithstanding who the next president is in Mexico.
Okay. Interesting. Okay, great, thank you. Jose, can we try your connection again?
Is this better, James?
This is much better. The feedback loop's gone. Take it away, please.
Okay, thank you, and apologies to all. So I was saying, first of all, good morning to everybody, and a pleasure to be sharing this panel with my fellow speakers. As Rose was telling you, I will give you an overview on Mexico macroeconomic situation and on the investment grade considerations, at the risk of being a little bit repetitive on what Jorge just explained, because many of the points touch on the same topics. I will start with some basic context on credit ratings for context of the audience. As you all know, countries' credit ratings reflect the payment capacity of a country to pay its debts, considering its income, spending, existing debt, tax and economic policies, and the macroeconomic conditions. The main macro levels of credit ratings are investment grade and high yield. The principal rating agencies, as you all know, are Moody's, Standard & Poor's, and Fitch Ratings. Where does Mexico stand currently in terms of its credit ratings with these three principal rating agencies? With Moody's, we are 3 steps from losing investment grade on the sovereign rating. We're at Baa1. This rating was revised on April 17, 2020, and has a negative perspective. With Standard & Poor's, we are 2 steps from losing investment grade. We are at BBB. This grade was issued on March 26, 2020, with a negative perspective. With Fitch Ratings, we're at BBB minus, 1 step from losing investment grade, and this grade was revised on April 15, 2020, with a stable perspective. What's the rating forecast and the macroeconomic context, and what should we expect to happen with these sovereign credit ratings? Well, as it can be expected, it is expected that credit ratings will continue deteriorating due to the following factors. First of all, a recession that should be around the levels of 9.8% in the GDP in 2020, mainly because of a decrease in the demand of goods and services. 2, the continuous deterioration of the financial and operating situation of Pemex, as Jorge was explaining, which is an entity that represents an income from the country of 9% of the GDP. The counter reform to the energy reform that Jorge also mentioned, that has been signaled by the Morena party, which, as many of you know, is the party that currently controls the executive and legislative branches at the federal level, and also in many of the states that comprise Mexico. This counter reform could put at risk billions of dollars of investments that have already been made in Mexico, and will kill potential billions of dollars in investments, in new investments to be made in Mexico. This is one of the major concerns. As you know, the energy reform was implemented during the tenure of Enrique Peña Nieto in the years 2012 to 2018, and basically it opened the energy market to the private sector. And Morena has been given some signals that they will try to, counter that reform and get things back to where they were, which was an undeveloped energy sector. Finally, on sustainability of the economic policies and packages of the current administration, that has been a continuous trend. All these factors, all these 5 macroeconomic factors that I just mentioned, are within the considerations of the rating agencies in the issuance of their latest ratings and the perspectives that those ratings have, and thus the future of Mexico's sovereign credit ratings does not look very, very good. Another good example of the foregoing is the Mexico Investor Survey issued by Credit Suisse this month, that touches upon many points on foreign and domestic investments, but particularly in the point of investment grades, of credit ratings, showed that all investors that were part of that survey expect Mexico to lose its investment grade in AMLO's tenure, with at least 2 of the 3 big agencies that I just mentioned. So what are the opportunities we see? Because as you all know, and I always like to see there should be a bright side to the story. We really believe that the current economic context will create activity in M&A as a result of a shift from low and mid-risk investors to more high-risk investors. And this will start happening, has started happening, and will continue happening as long as the forecast for Mexico continues to deteriorate. No, we'll be seeing more conservative investors, foreign and domestic, moving out from the country, and more aggressive investors moving in. And this will certainly generate activity in the M&A sector. Also, a distressed market posts interesting conditions, right? Basically, in terms of the terms you can get, we have started seeing, good opportunities to acquire assets, no, where sellers are willing to provide buyers with very attractive terms for such investments and very, very attractive returns. And that is also a good opportunity that we think will generate activity in our country in the following years. With that, I would like to get it back to you, Rose, to maybe pose some questions on the topic for the panel.
Thank you, Jose Ignacio. Indeed, I mean, the political and the economic context certainly has an impact on a general counsel's role. So I would like to turn to Raul and ask, how has your role been impacted by the political uncertainty? In particular, compared to the last two administrations, what has the changing policy of the López Obrador administration meant for the energy sector?
Thank you, Rose. I think this is a very complex question to answer in 5 minutes, but I'll try to be as brief as possible. You see, the uncertainty, what it generates, it's a level of discussion with your clients, a series of legal actions that need to be done in order to preserve the company's rights, and then an analysis of the policy of where this administration is heading in order to clarify and help senior management take decisions in terms of investment in the country. What really has struck me as interesting is that this administration has had different, what I would call acts in different stages. So by changing some of the policies in the energy sector and giving signals to the market, it has achieved what I would consider their first goal, which was since the beginning of this administration, it was clear that they wanted to have a bigger space for Pemex and CFE. And limit the investment of the private sector to specific areas where they would not like to have competition or would not like to invest themselves. And that generated a series of actions that had been well thought in the different stages. And I'll try to explain this. In the first stage, when we were in the electoral mood and post-electoral mood, the current administration tried to send a message that was clear. It was explaining, yes, we want Pemex and CFE to have a higher, or let's say a more dominant role in the current market. We'll abide by the contracts and the regulations that exist. And nobody should be worried because we're gonna respect the energy reform. So that was what I would call the honeymoon phase in the first act. Even though there was a clear policy in terms of what were the priorities of this administration, for instance, the refinery in Dos Bocas, and other actions that had to do specifically on where they were planning to invest their limited resources. It was clear that was the first stage. The second one came with COVID. So Pemex faced an unusual situation because of the lockdown at the national level. The consumption of gasoline dropped tremendously. Then CFE had an analysis of how to dispatch their facilities, and they tried to limit the participation of the renewable plants that were coming into the market in the test run phases prior to COD. That generated a second round, or a second act, let's put it, a confrontation of the new policy that tried to generate conditions favorable to the state-owned companies, and that had an impact on the market at itself, both for the consumers and private generators. And that causes a second wave of legal actions and challenges by the private sector. We're currently, and I will say, starting the third act in this administration, which will be how can we push this agenda further? And they have realized that it's necessary to have a constitutional amendment prior to doing anything else, because there is so much you can do by regulation and policies. So it's necessary to consider what would be the next action. And I believe, and this is my personal opinion, I want to clarify this. This is in no way the opinion of my company, that this is going to become an electoral matter, and it's going to be part of the mid-year, the next year's election in Mexico. Because in order to have that constitutional amendment, it would be necessary to gain majority in the state legislatures, which at this stage, the current administration does not have. So that I would try to sum it up, and I don't know if I exceeded the time limit, but I would like to close with that. Thank you, Rose.
Thank you, Raul. And yes, speaking of how uncertainty affects the economic activity, I would like to turn to Jorge Dengo and ask you, Jorge, what does uncertainty in rule of law mean for Philip Morris? I mean, in particular, if we take new product categories, such as, let's say, alternative nicotine products, how have the policies of the López Obrador administration affected your approach to the M&A sector here?
Thank you, Rose, and good morning or afternoon, as the case may be, to everyone. Thank you, Legal 500, for organizing this, and González Calvillo for being the sponsor. It is a pleasure to talk to to so many colleagues today and to be part of this distinguished panel. And jumping right into the question and thinking about M&A, I think that when you may look at the transaction, the parties involved, the due diligence for that sense, assets, litigation, tax standing, but the most critical aspect of M&A is the legal certainty and the environmental stability in which the transaction takes place. In the case of particular of the tobacco industry, with the López Obrador administration, the case has been a bit negative. So let me give you the example. As you may have heard about these alternative nicotine delivery products, many people know them as electronic cigarettes, but the category is much broader. Our company, Philip Morris, has developed one of these products, which is a heat-not-burn device, which basically heats tobacco that produces an aerosol that has 95% less toxics than when compared to a cigarette. And we have been trying to bring in this product into the market. And I'm not trying to make a sale of the product, but the context of this product around the world is that it is widely sold, but interestingly enough, banned for production, sale, commercialization, importation, and exportation in Mexico. Jorge was mentioning earlier the context of the US-Mexico-Canada Free Trade Agreement. And out of those three partners, only in Mexico, these products are banned. Even in Canada, who has a long-standing battle against tobacco, these products are allowed for sale, obviously with some regulation. And in the US as well, these products are also allowed for sale. And PMI device in particular, which is called IQOS, has been authorized by the FDA to be marketed as a modified risk tobacco product. We haven't had that luck in Mexico. After many years of submitting information, bringing in scientists, our company finally obtained a resolution from the head council of COFEPRIS. For all of you that are not here in Mexico are not familiar with COFEPRIS, COFEPRIS is the FDA equivalent in Mexico. And in this resolution, our device, IQOS, was declared as an electronic device that only had to comply with local norms applicable to electronics. The consumable, which contains tobacco, known as HEETS, on the other hand, were included as products that fall under the tobacco control law. No surprise there. It's what we expected. That gave us really a blanket of certainty, of legal certainty. And under that blanket of legal certainty, we developed a major business plan to bring in these products into the market. However, our surprise came early in the early stages of the current administration, the AMLO administration, when with a series of resolutions of COFEPRIS, they disregarded this previous resolution. In one shocking decision, for example, COFEPRIS declared that HEETS, which is the tobacco consumable, and which is a product that contains tobacco and that pays the excise of tobacco, the IEPS, was not a tobacco product, which is kind of funny if you ask me. Our surprise was even more significant when earlier this year, the president, in one executive decree, created a specific customs tariffs for devices, consumables, and accessories. But following the creation, he issued in the same decree a ban on importation and exportation of all the products under these classifications. And believe me when I say that we have tried to have an open dialogue with the government. But as I said, we have had no luck. A whole industry which is making billions of dollars around the world and that could be driving many transactions such as acquisitions, tech and manufacturing agreements, mergers, reorganizations, is totally locked out of Mexico. And for no reason, really no reason whatsoever. Therefore, due to government activity, all potential M&A activity in this particular subject matter is closed, and plenty of opportunities for Mexican entrepreneurs are lost as well. So going back to my initial premise, I would say that legal certainty and political environment are at the top of my list when it comes to M&A transactions. And right now, at least in the case of our industry, the tobacco industry, that in Mexico is missing. So I hope that I answered your question. Thank you, Rob.
Thank you for your insight, Jorge. This has been very, very helpful. As we have discussed, the energy sector has been especially targeted by AMLO's administration. So I would like to ask Tom, how have regulatory changes in the power industry in Mexico and in the midstream sector specifically impacted your M&A activities? I mean, with all the shifts in policy under the current administration, how has due diligence been affected? Thomas?
Thank you, Rose. Good morning, everyone, and thank you very much to Legal 500 and my good friends and former colleagues at González Calvillo for putting this event together and for the invitation to join this panel. It's a privilege to share it with you guys and with Raul and Jorge. And regarding your first question, Rose, we are facing an erosion of the rule of law, as Jorge and Raul very well mentioned, and hence the wave of constitutional challenges, amparos as they're known in Mexico, against these regulatory measures Raul mentioned, namely the Ministry of Energy's reliability policy and the CRE, the Energy Regulatory Commission's resolution increasing wheeling charges by 500 to 1,000%, depending on the circumstances. So that's created a sea of uncertainty where the rule of law legal security and legal certainty are concerns. And that's causing investors such as us to shift our attention away from renewable projects towards other infrastructure assets, even though we're not completely discarding power projects or forgetting about them. However, we are looking at them more conservatively. Our risk tolerance and appetite has certainly changed in light of this. It's focused our analysis on factors such as the ability to pass through wheeling charges to off-takers and whether there are limits to this pass-through, for example. And then specifically regarding portfolios with legacy projects, that's a very risky area nowadays, given the government's targeting of these projects and renewables in general. And what's worrying regarding legacy projects is the CRE's inaction in resolving applications to modify power generating permits to include new off-taker partners in those permits, thereby affecting or even jeopardizing the viability and profitability of these assets. So we are cautiously looking at power projects, in particular renewable ones, but more conservatively than we would otherwise do. And we are, as I mentioned, shifting our attention to other categories of assets within infrastructure. And then a climate of uncertainty has also been created in midstream projects due to the forced renegotiation of gas transportation agreements last year with major players in the pipeline industry. And the federal government's recent announcement that the CRE will not grant any new permits to private parties for transportation and storage activities, in addition to permits, the power generating arena, which we had already mentioned. And to answer your second question, Rose, we have changed our focus in due diligence when evaluating investments in or acquisitions of renewable power generation projects or assets. One approach we've been following is to focus on our due diligence on PPAs to determine whether wheeling charges may be passed through to off-takers, and if so, to what extent, or within which limits or parameters, among other aspects of the actual offtake contracts, before starting full-blown due diligence in order to save costs and to determine whether we're prepared to move forward with a potential investment in these categories of assets. So yes, our due diligence has become more thorough, more focused, and we are evaluating risk in a different light than we would have otherwise done, because as my fellow members of the panel were mentioning, there's a blatant and evident effort by the federal government to unlevel the playing field and strengthen government players such as Pemex and the CFE. And a few months ago, or actually at the end of last year, the CFE made a wish list asking for all kinds of regulatory changes and rollbacks to limit private participation in the power generating industry, and specifically targeting renewables projects. And the CRE seems to be fulfilling those whims of the CFE. And that's especially worrying in light of the rule of law, because the CRE is meant to be an independent regulator, and it's now becoming an instrument of the federal government, and in particular, the Ministry of Energy and the President.
I
Tom.
agree, and thank you.
Tom, may I add something there to what you just said, Tom, about the CRE? And,
Sure.
and it is worth mentioning that all of the actions that the AMLO administration has taken to affect private participation in the energy sector has resulted in litigation, has resulted in the private participants filing lawsuits and amparos to protect. And some of these litigations have been favorable to date against all of these changes that they have been making. So you have the government creating these, trying to create this field where they're favoring Pemex and CFE in violation of existing laws. And then you have the private participants in the market litigating, obtaining suspensions against the applicability of these laws and moving forward with their projects. But all of this obviously creates legal uncertainty that generates a lot of questioning to be done by the private participants. I just wanted to add that, sorry.
No, and I think that's actually very important, because, and this is an open question for all our panelists, how significant are judicial resolutions in ensuring promises will be respected? I mean, in your opinion, how likely are constitutional amendments to affect the energy sector?
I can start answering that question. We have been pleasantly surprised by the way the Mexican federal judiciary has been handling these challenges in general. The federal judiciary has gone a long way in recent years in terms of sophistication and effectiveness, with judges becoming more increasingly versed in complex commercial matters or in understanding regulated industries such as the power industry and competition matters. Specifically, the district courts specializing in competition matters, which have been hearing these challenges and granting injunctions against these regulatory measures we've been mentioning. And then the recent injunction granted a few days ago by the Supreme Court against the Ministry of Energy's reliability policy have been reassuring for participants. And then another important factor to consider is that failure by government officials to comply with the judgment in a constitutional lawsuit is a criminal offense. So that should be reassuring to private investors. And then another important player to consider, which continues to be independent and has shown objectivity and has been defending the free market created by the 2013 and 14 energy reform, as the Federal Competition Commission, which filed a constitutional action in the Supreme Court, which has resulted in an injunction with general effects against the reliability policy, which will be effective until a final judgment is rendered by the Supreme Court. And then you also mentioned the likelihood of constitutional amendments which my fellow participants touched upon. I think that's a $1 million question. It's certainly within the ruling party's playbook and agenda, but I guess we'll have to see how it plays out because of the super majorities required in both chambers of Congress and the state legislatures. But I don't want to hog the microphone, so I'll turn it over to my colleagues.
I just want to add something on Tom's response. I think, and I'm afraid I'm not as optimistic as he is. We have to remind that we have a president that has disregarded judicial orders in the past when he was the jefe de gobierno at Mexico City, at the risk of the criminal liability he had. And I think we've also seen a president that wants to take over the institutions, and that does not exclude the judicial system, no? And there have been, I think, as Tom was saying, very encouraging judicial resolutions, but on the other hand, there have been others that have been heavily criticized and are very, very worrying. So I think I wouldn't feel completely comfortable in Mexico's judicial system. I really hope the judicial system remains independent and applying the rule of law. But again, we have a president that tries to control everything, and a president that has disregarded judicial resolutions in the past. But that's just my personal opinion, and I let the other panelists give theirs.
If I may jump on that idea, Jose Ignacio, I completely agree with you. And out of the somber scenario that I was painting for our industry in particular, we have been resorting to the Amparo route and as many others. And so far we have been successful, or there have been successful cases in which the courts have acknowledged that all of these provisions violate constitutional rights. But we are seeing more and more that specific what you were saying of government lobbying at court, honestly, putting pressure into not only circuit judges, but even at the higher levels of the judiciary. And that is an aspect which I think is troubling. It's something that we have to closely look at, because once the judiciary lost its independence, then you have a really big trouble.
Sorry, yeah, those are really interesting points of view. And I guess we'll see where this takes us. There's nothing written in stone here. And I would like to move forward with the discussion and take a closer look to M&A trends in infrastructure and energy sectors. For this, I would like to ask Nando if he could please take us through an overview of the balance between renewables and opportunities arising in highways and ports. Nando, what's your take?
Thank you, Rose, and thanks to all the panelists for being here and all the attendees. Well, it's interesting. We've been talking about energy, and as most of my fellow panelists have discussed, back in 2013, December 2013, the energy reform was enacted, which led into a trend of investments in energy. Only the power sector it's worth more than $20 billion to date. So the interesting part is that this administration, as Jorge and Raul specifically mentioned, and Tom as well, this administration has been placing or implementing new policies which clearly go against the current or the energy reform. Thus, there has been more risk in investing in power in this past year. However, there's still some opportunities that may be available to some investors. Like Jose Ignacio was saying, there may be other type of risk appetite from investors. Also, there may be long-term investors that may be interested in this type of assets. And the reason for that is because the pricing of this type of projects and the conditions for sellers in this market are not the best. We've been hearing in other forums that some of the current developers or investors in this market are selling their projects because they want to divest in Mexico. But there's other individuals or entities or funds that may be interested in those projects, obviously at a discount or at better conditions. Also, we've been seeing a trend of sales or transactions in global portfolios of this type of assets that are moving. But all of this, it's because we've been in a momentum of energy projects in Mexico, and it seems we're losing that momentum due to the current administration policies. However, there are other opportunities in other sectors. Interestingly enough, probably the energy sector could be the one that could bring this profound recession that we're living in Mexico. It could help, really help to overturn this recession. However, there may be opportunities in other type of assets such as ports, highways, trains, other type of energy projects, and social infrastructure that's well needed in our country. For example, if you can remember back on October, the first days of October of this year, the private initiative and the government signed the Plan de Reactivación Económica, which is the economic reactivation plan. This plan refer to either constructing or revamping new ports, the construction and granting concessions of approximately 20 highways or toll roads to private entities, the construction or revamp of certain trains, and also it included other type of social infrastructure, such as water concessions. Let me talk about this social infrastructure. It's well needed in the country. So a lot of investors that were looking into energy projects, obviously big investors that have a different type of portfolio, are looking into this social infrastructure. Hospitals are needed in the country, water and other type of assets will be required. So there may be opportunities in this type of assets in the near future. So this takes me to one word: risk. As all of the panelists have been discussing, it's a matter of risk. The current administration have created uncertainty. So we see a trend of investors seeking to share that risk. So instead of going alone into one of these investments, they're going to try to share that risk with other players, either developers or operative funds that operate this type of assets will try to divest or sell a part of their assets in order to minimize or somehow mitigate that risk that the current administration is posing. With that Jose Ignacio, I think you were going to talk about other opportunities, not in the infrastructure sector, but in other type of financial opportunities. Thank you.
No, thank you, Hernando. And I think it has been very clear that the energy sector will not be the way to go in the next years. No, there will be activity, but it's definitely a sector that is not being favored by the current administration. And that's not very good news for investments there. No, Hernando already exposed other sectors that might result interesting for investors nowadays. And I wanted to point out another one, no, that I see represents a niche for investors in general, no, and this is the fintech sector. I think the fintech sector in Mexico, and understanding fintech broadly as the rendering of any type of financial services through electronic media, has been very active recently, and that's because the enactment of the fintech law, which is a very new law in Mexico that basically allows for crowdfunding and for the implementation of payment mechanisms or payment entities. And also, believe it or not, by the COVID-19 pandemic, because the pandemic, one of the few good things that the pandemic has brought upon us is that technology, we advanced 20 years in technology in 8 months or 9 months. People are starting to use technologies everywhere and in every industry in general. And this is a good example of it. No, that's not the exception in financial services. And with Mexico having a huge portion of its population being unbanked, there are huge opportunities to create business there with all those potential clients, no, and that have not been able to reach the traditional banking system or vice versa, no, for many reasons. So these new platforms where you are seeing, the possibility of not only getting a credit but disbursing it from your phone and using it from your phone, sending money to your loved ones. So all these type of platforms have been very, very, very interesting. Today, I was seeing in the New York Times that Ant Group, which is a Chinese financial tech firm, is making what's one of the largest initial public stock offerings in history. Their subsidiary, Alipay, has more than 730 million monthly users. So I think this is just an example of an international case of what we're talking about. But I really think that Mexico has a huge potential in this part and a huge business to be developed by foreign and domestic investors. Financial services are generally open to foreign investors, and we have started to see this. No, one very good example is the joint venture that was closed between Rappi and Banorte. No, Rappi, a technological platform, and Banorte, a traditional bank in Mexico. No? So I think this is definitely a sector where investors should be looking at. Thank you, Hernando. I give it back to you, Rose.
Thank you, Jose Ignacio. Thank you for sharing. And now let's turn to Raul, whose experience comes mainly from working on the side of long-term buyers. And my question to you, Raul, is what changes have you seen in the energy sector here? Are you seeing more moves from investment funds, strategic buyers, and operators when it comes to buying potentially distressed assets?
Thank you, Rose. This is a very interesting question. You see, this depends, and I think Fernando mentioned the topic that was risk. The risk appetite that the different companies have and their trust in two factors. One, it's the independence of the judiciary in terms of what could be achieved long term. And then it has to do with the actual market structure and the needs of the market in Mexico. I differ a little bit of what Jose Ignacio mentioned in terms of, I do not necessarily see that there would not be an appetite to do transactions or develop projects in energy. What it may change is what type of projects are going to be implemented. And what I understand is the fundamentals of technology are the ones that are going to dictate what happens in the short term. If we're able, and I'm just talking figuratively speaking, to find a technology that is much cheaper than the current technology, that technology will be the preferred technology in the short term. So in a technological sense, I see that there are a series of companies that had, well, let's put it like that, a limited amount of tolerance to risk, or they needed to capitalize themselves again and start their process to move to other markets. Those companies, yes, will be the first ones selling. There would be a second trend of funds that are thinking, well, the conditions of the Mexican market will require these type of projects in the medium and long term. And those are the ones that would be acquiring. But I think, and this is the reality of things, it will depend on the confidence that you have on the institutions and the regulatory framework. If that changes, then you really would not have that appetite. You can put your money somewhere else, right? So in the short term, yes, there is a lot of uncertainty. I think part of it was cost. In order to move the needle a little bit in terms of what could be achieved by the state-owned companies. But in the long term, the needs of a market of 120 plus million people and an interconnection to the US market will generate different conditions. So that in the short term means that you will find companies that are interested in playing the long game and having that investment continue to be done.
Thank you, Raul. Thank you very much. And what about the impact that social movements have had in the way you calculate risks on new projects? Could you share, Tom, please, if there are any opportunities generated by this adverse climate? How are you thinking about this?
Yes, Rose, to answer your first question, social movements are becoming an important risk factor when developing projects in Mexico, unfortunately. We've been seeing or reading about, or even as practitioners, having experiences of social movements blocking the development of projects. For example, one that was in the news recently and which González Calvillo worked on is the Topolobampo ammonium plant developed by the German conglomerate Proman in Sinaloa, which has been entangled in all sorts of social issues where social groups have been filing constitutional lawsuits to injunct the development of the project. And it's been a constant turtle. It's been in the news recently. Then there have also been cases of social movements blocking the development of wind projects in the state of Oaxaca. and then the filing of constitutional lawsuits challenging the awarding of EMP contracts in deep waters. And that's just to mention a few. Then another incident which was in the news recently was the social unrest or movement surrounding the construction of a brewery in Mexicali by Constellation Brands, where the president ended up calling a public consultation of dubious legality, which ended up stopping a multi-billion-dollar project, adding to this climate of uncertainty. So these social movements and social unrest have become a significant risk factor when acquiring portfolios of assets. I was going to say infrastructure, but it's spilled over to other types of industries, such as the brewery I mentioned. And this also creates the need of a more thorough and deeper due diligence project, and not to mention the need of hiring counsel specializing in social impact and other social matters. For example, things to look out for in a due diligence process when acquiring these assets is determining whether a social impact study was carried out and duly approved by the Ministry of Energy in the case of energy projects, broadly speaking, or whether an indigenous consultation was carried out. And there have been instances of agitators or groups of agitators posing as indigenous groups or groups of fishermen, which are evidently organized by local power brokers or interest groups seeking to make a quick buck and jeopardizing or delaying the development of projects. And what does this mean to a potential acquirer? More legal expenses and a slower acquisition process. And then social movements or social impact is also relevant for purposes of rights of way and easements in energy and infrastructure projects, whether it's pipelines, power generating assets, transmission lines, what have you, roads, toll roads. And going into your second question, opportunities of this adverse climate, I'd like to first mention that private equity funds and asset management companies in general take a longer term view of risks in these assets with varying degrees of risk appetite. So as I mentioned earlier, we are not completely turning away from power generating assets or midstream assets in the oil and gas industry. Simply our risk tolerance and appetite has changed. And related to that, the market for power projects and midstream projects is becoming and will increasingly become a buyer's market. So we will likely see more M&A activity surrounding those categories of assets. And not to mention restructurings and opportunities to acquire these assets in the context of a restructuring, which I think will be discussed later in this event. And then in terms of other assets where there are areas of opportunity for investment, are other subsectors of the infrastructure industry. such as toll roads, water and sewage projects, water treatment, telecommunications, assets, ports, airports. So there is still quite a bit of fabric to cut from. Potential acquirers, whether strategic buyers or private equity funds, simply need to be on the lookout for these types of opportunities in the market, working hand in hand with financial advisors. Oh, go ahead, Jorge.
I think, Tom, that you're pointing your finger at exactly something that we are seeing also in our firm. The market is huge. There is legal uncertainty. There is movement in the political cycles, etc. This will still, I believe, will not affect overall the ability to do deals. It just means that the deals become much more complex, that the deals have a much higher regulatory framework through which you need to work around because of all these considerations we have been discussing. And it means that for sophisticated investors, they will understand that it's a buyer's market in all of the sectors we're looking at. So we see tremendous potential to do large deals, small deals across the board in all of the sectors that we discussed: automotive industry, aviation industry, fintech, infrastructure, financial services, energy, etc. I think as a law firm, at least, we see that all of these transactions will require the use of sophisticated counsel and will require the use of advisors that understand the social and political context in which you're operating, the country in which you're operating, and these firms like ours will be able to tell you how to do the deal. I mean, there's obviously enormous risks always when you do deals. There's always a risk when you do a deal. But I think the crux of the matter is, how can we do a deal, identify the risks, and work around them? And that is going to represent an opportunity for firms like us and for buyers that are listening to this conversation and outside. And that's what I think. I would like to leave this optimistic note on the in the conversation.
Absolutely, Jorge. You mentioned something very important. We as investors, whether strategic or private equity investors, look for that added value in our legal advisors who tell us how to do the deal, taking an integral and well-rounded approach to the transaction. You need a strong M&A transactional financial team, depending on the particularities of the deal. You need a strong regulatory team, a strong litigation team, and within that subset, people specializing in social and environmental matters, in addition to competition. And that's something a firm like yours offers the market, and that's certainly the approach firms both in Mexico and in the US doing business in Mexico should take. Offer this integral approach, giving that added value consisting of, here are the risks, evaluate them, which of these risks constitute absolute obstacle to getting the deal done, and which of these risks are risks you can live with, and here are the mitigation measures or measures to address them. And just to conclude this intervention, another bright spot in the Mexican market is industrial real estate. That's a bright spot in light of the USMCA, which has been recently driving foreign direct investment in Mexico. And as I read in the news article recently, I think 2 or 3 days ago. It is currently the largest driver of foreign direct investment in Mexico, given the unfavorable circumstances in other areas. But that agreement is certainly driving things in the right direction for us. And specifically regarding industrial real estate, there are vast opportunities in the so-called NAFTA corridor from the Mexico City metropolitan area to the Texas border. You've got opportunities here in the metro area for large industrial estates and plants and logistics centers or developments. Then the Bajío industrial corridor from Querétaro to Aguascalientes, where many automotive factories are, in addition to other types of manufacturing facilities, are also offering fertile ground for investors such as us. And then the Monterrey and Saltillo metropolitan areas and cities along the US border like Laredo, Ciudad Juarez, Tijuana. So we are seeing a lot of activity in that sector in those regions I mentioned. And our numbers in particular are looking pretty good. We've had good returns in our industrial real estate portfolio. So that's also an interesting area to look at. And for attorneys, it offers its attractiveness and challenges, because a lot of these investments are carried out through complex joint venture structures to develop greenfield sites. Then there are outright purchases of brownfield sites. And then, since a lot of these counterparties, which are large landowners or local families, lack the degree of sophistication specialized funds have, they also have a need for sophisticated counsel to assist them in negotiations with players such as us.
Great, excellent. Look, thank you very much, Tom. Sorry to cut in there. Before we move on to the third and final section, I've noticed we have had some questions come in from the audience. One asking about cannabis, and that came up on the prep call when we were discussing new product categories. One about SPACs, special purpose acquisition companies. We'll try to get to those after this section, but just a reminder to you in the audience, if you have any questions, comments, do please use the Q&A function. We want to hear from you as well. Rose, I'll hand over to you to lead us through the third and final section of the webinar, please.
Thank you, James. So we have talked about the political and economic context and how it affects the M&A sector. We have also reviewed current and future opportunities arising within the country. But what does this mean for general counsels? I mean, which issues have arisen so far and how are they facing them? To begin with, how have legal teams been impacted by the pandemic? And I would like to ask Jorge Dengo, how have you coped with remote working and digitalization? And how has this affected the way you approach M&A?
Well, I don't believe it makes much difference whether you're working in M&A or just doing more traditional work. Certainly, M&A would be more challenging in the sense of the amount of information that is shared in an M&A transaction, and the fact that, in my experience, the M&A is a collective effort which requires groups getting together to work and to move forward into the transaction. But as many of you, we have turned, as you said, to digitalization. This type of medium, Zoom, Teams, whatever, is a must. Information repositories need to be online and available for the team at all time. fluid communications are a must, and indeed, we are using more and more electronic signature, not only in agreements, but we have learned that to extent possible should be implemented as part of the corporate governance of companies. So we are doing a lot of that. And I think, and this is my last reflection on this matter, that in the context of a pandemic, us lawyers are learning to put more attention to contractual clauses that usually were just part of the template agreement. You know, the force majeure, the alternative means of dispute resolution, even the rebus sic stantibus clause. And I think that we are looking at these contractual terms in a whole different light, a whole different view, because if the pandemic has show us something, is that things will not go as planned, and that is that.
Awesome, thank you, Jorge. I agree. I would like to open the mic and ask all of our panelists, what are your top tips for doing M&A successfully? What are 3 lessons that have you learned from your time, working in M&As? Anyone like to take this?
Yes, I'd like to touch on a point that was already raised by Jorge Cervantes, which is the top tips for doing M&A in Mexico nowadays is getting good counsel. Not having good counsel in these days in Mexico could come at a very high cost. You have to have good counsel, either external counsel or internal counsel, but you really need to invest so that you can have a really good overview on your risks and be able to take intelligent decisions. That's the thing that sums up everything else, but particularly you have to do very good due diligence, and you have to implement legal mechanisms that minimize your risks. This type of mechanisms can include guarantees, personal and asset-based guarantees, reps, warranties, indemnities. And if you are coexisting with a partner, you have to make sure that you install the rules that will allow you to have a healthy relationship with your partner, and also rules that will incentivize agreements when you have a discussion or a break-in decision. As for the lessons I've learned in M&A, I'll say the first and most important is to be deal-driven, right? And from that, I will say you should never take things personally. You really need to understand your position as counsel and never let your ego go into the negotiation. Your position as counsel should allow you to inform your client of the risks, but you need to understand that the client has the decision, and you should never make it personal and let your ego get in the table or break the deal. Clients like to make deals, and you need to facilitate making the deals for them. That's what I would say.
I couldn't agree more. Thank you, Jose Ignacio. And just one more question before moving to questions from the audience. And this is open to all of our panelists. And it is, to what extent has changes to laws and policies under the current administration affected things like force majeure clauses? Would anyone like to further discuss this? I think, force majeure.
I will.
Thank you.
I can give an initial thought, but I think it's interesting if any of the general counsels can say something about it. But the initial thought is this: obviously, when COVID hit, everyone was asking about the force majeure clauses and whether COVID was covered or not, and whether this clause would allow them to exit the agreement or modify the agreement, and whether the pandemic in fact became an act of God or a force majeure event that allowed them to terminate agreements earlier, reduce payments, or get out of the deals altogether. And what we have seen as a firm in analyzing all of these force majeure clauses is that they are all very different, and they are interpreted differently depending on whether it's New York law governing the document, whether it's Mexican law, whether there's an arbitration provision that mandates previous mediation or some sort of arrangements before, and what the civil code says in Mexico about force majeure and how it is interpreted by courts. So definitely, this is one of the clauses that moving down the line will be included in contracts with a very specific reference, I believe, to pandemics such as those arising from the COVID-19 disease and things like that. And it's impacted, and it is something that the general counsels on this table and outside should be thinking about in their templates of agreements, how they deal with it, is it covered or not, etc. But it's certainly something that in the past we looked at force majeure, but not like we are looking at it today.
Yes, adding to what Jorge mentioned, it's a clause that merits more attention nowadays and should not be treated as a mere boilerplate clause or boilerplate definition, given conflicts that may arise down the road. In terms of changes to laws, policies, or regulations by the current administration, we are seeing a trend where parties are pushing for the definition of a force majeure event to include change in law, broadly speaking, including regulations, in stock and asset purchase agreements, joint venture or investment agreements, and financing documents. So it's something that's become more and more relevant. And clauses that, due to this pandemic, have started to materialize. And at Macquarie, we've been analyzing existing force majeure clauses and fighting back their invocation by tenants, for instance, who have sought rent reductions or rent deferrals. And there we have taken a case-by-case approach to see if there has been an impossibility of the performance of the counterparty's obligations.
Thank you, Thomas. I think Raul also wants to weigh in.
Oh, I agree with what has been explained. The only point, and I think this is what Thomas was going with it, is the facts around it and the willingness of the parties to think about the context. And let me just try to be brief. When you have, let's say, a client that consumes a product that you provide or a service that you give, it is different when they say, oh, I have an economic constraint derived from the force majeure, and I would like to have an extension of my payments. Okay, that's one scenario. And the other is, you know what, I'm ordered to shut down my facility because I cannot operate, so I cannot consume. It's a different scenario. So there is not a single response to it, but what has happened is that there is this trend of reviewing these clauses, because a lot of companies have said, well, could I take a better position of it? Could I claim force majeure to delay payments? Could I argue certain conditions not to fulfill my commitments? And I think it becomes more factual, and it is very important to have the willingness of the parties to talk openly and understand the conditions of the market. If you cannot import a product that is key for a specific or a supplier that cannot deliver it because the customs are closed and you cannot cross it, then you have a different element than, well, let's just take advantage of it and wait for a while and see when I can send it. So that type of things are the ones important in terms of reviewing the context of the applicability of those force majeure clauses. And so that was it. Thank you.
More question from Ligia Gonzalez, and she asks, are the elections next year a factor to be evaluated in the risks? And what are the chances for a constitutional modification as to close the doors retroactively to the private investments in energy?
If you want, I can take that, and Jorge and Thomas can add to it.
Okay.
I think so. I think it's part of the assessment of the risk assessment that the different players in the energy sector need to make. For example, one scenario could be that the Morena party takes a majority in Congress and also of the local governments in the country, thus allowing them to modify the Constitution practically at will. So that could be one of the assessments. The other scenario could be that the Morena party loses Congress and doesn't have the ability to change the constitutional will. That would be for the people or the companies that are in this market, would be probably the best scenario, because that means that in order to make or to change the constitution or amend the constitution, the Morena party will need to make concessions and have agreements which levels the field a little bit more for the players in the field. As to the last question, would it change retroactively the regulations for private investments in energy? I mean, anything can happen with this administration, but I don't think they will. They've had mentioned that they will respect the permits that have been granted. Obviously, some of the current regulations have had effects in the permits that were granted in the past. But as a mechanism of defense, obviously, you have the amparo procedures, but also the international arbitration procedures in case this type of amendments go through, because it would be tantamount to expropriation in some cases. So I'll leave it as that. Jorge, Tom, if you want to complement what I said, go ahead.
I would add two comments to what you just said, Hernando. One, I would not base a decision on an M&A transaction on a consideration that the government of Mexico, the Congress, is going to change in 2021. I would certainly analyze what the situation is and see what it means. And there's a possibility that they might lose the majorities, but there's a possibility they will keep them. I think you cannot base the decision on the assumption that they're going to lose the majority. If at all, you need to consider that they will continue to control the legislative, the executive branch, obviously, for the next 4 years, which is the term left in this administration. So I think you need to ask yourself whether or not there's a change in Congress and in some majorities. This might affect their ability to pass laws and to do things, but it will not dramatically, I think, change their political vision and how they want to move the country forward. That's one comment I would make. And the second comment I would make is that, at least in law school, they taught us that you cannot apply laws retroactively to affect existing projects and businesses and permits. So I don't believe, I think they can pass laws that go against existing laws moving forward. But retroactively, you go into what Hernando's explaining of saying this would be a violation of existing Mexican federal law, of the Mexican Civil Code, of NAFTA, and of many other legal provisions, which would certainly give rise to important litigation against the government. Tom?
Yes, I concur, Jorge. I think we need to assume that the president and his ruling party will continue to have majorities and in general political control of the country. Even if he loses his absolute majority in the lower house, he has concentrated so much power in the executive branch that I doubt there will be much of a difference. There could be slightly more checks and balances, and it could be more difficult to pass constitutional amendments, but the Senate is not up for grabs next year. And right now it's too early to tell whether the party will lose its super majority in the lower house, but we are assuming in our risk calculations that they'll continue to have a hold of the lower house, perhaps not a super majority, but a working majority probably, especially in light of the alliances and horse trading with the minor parties. And as I said, the executive, Mexico has a very strong executive, and this president in particular has been adamant in expanding executive power. And then you all have mentioned international arbitration as a recourse. Rolling back the energy reform and affecting vested rights retroactively would give causes of action in the Mexican federal courts under a constitutional lawsuits or amparos, and additionally under the dispute resolution mechanisms of investment treaties such as the USMCA, the successor agreement to the APP, whose name I don't remember off the top of my head, and the numerous bilateral investment treaties Mexico is a signatory of. And industry players such as us and many others in the power industry have been actively analyzing our options in investor state arbitrations, because these measures would constitute actions tantamount to expropriation. And there's also a practical use to investor state arbitration. It's more flexible than commercial arbitration in the filing of a trigger letter or notice of arbitration, which can be used as a tactic to force the government to sit at the negotiating table before commencing a full-blown arbitration procedure. So that's another angle we're analyzing individually and within the different trade groups we participate in.
Thank you so much, Thomas and Hernando and Jorge for helping us address this question. And I think that'd be all we have done.
I think we're coming up to the end of our time here, aren't we, Rose? I mean, there's a lot we didn't get to touch on. FCPA, UK Bribery Act, whether that's becoming more important in the context of Mexican M&A. Reps and warranties, the extent to which that's becoming more important, obviously an established part of the M&A toolkit in other jurisdictions. But perhaps if we can just very finally ask Raul and Jorge Denga if they have any thoughts on this question we asked earlier on top tips for doing M&A successfully. I don't know if you had any thoughts on that. We said we didn't get to hear them. So a final opportunity perhaps for Raul and Jorge Denga to contribute their thoughts.
Well, the only thought that comes to mind right now, and I think that Jose Ignacio covered it well, not doing a lot of M&As. We have one small one this year, is to retain really good outside counsel. That is vital for general counsel to have a strong support in areas of expertise that are not traditional or usual in the course of your business, and because you are handling business as usual. So for me, that'll be the first thing that would come to mind. Secondly, would be to really have well-ordered information, available information, so when you need to go into a deal, you have everything ready for it.
Yes, excellent. Thank you. Thank you. Raul, any final thoughts from you?
Yes, one point that I think as GC we have an obligation to do is challenge our own assumptions, internal assumptions. And let me try to be brief on this. Generally, when you're doing modeling of the commercial risk, we start with the status quo, or what we used to believe it was the status quo. If there is no one within your own team able to do that challenge, there is this series of assumptions that come afterwards and translate into economic models. One of our responsibilities is to think of these scenarios. And I think DJ's question was very interesting because it's one that you need to analyze. What would happen if they change the law? What would happen if they stop giving permits? What would happen if we need to present this investor claim? All of that helps you analyze and provide guidance to the senior management team. And I think that it's very important. If you need to seek expertise outside of your own company, do not be shy about it. There is a great group of attorneys and seasoned consultant that could help you on this. And I think that would be my main reflection on that topic. Thank you, James.
Thanks very much. Cheers. Excellent. Look, well, I think we should perhaps close it there because we're way over time. But look, firstly, thank you very much to Rose Harfuch for moderating. Rose, real pleasure hearing your moderation. Thank you very much. Thanks, of course, to all our speakers, Jorge Dengo, Philip Morris, Jorge Cervantes Trejo from Gonzalez Calvillo, Thomas Heather from Macquarie, Raul Felix Sol from Engie, Jose Ignacio Rivero Andere from Gonzalez Calvillo. Sorry, I apologize for butchering your names, guys. Hernando Becerra de Cima from Gonzalez Calvillo, and Jose Ignacio Rivero. Sorry, you're appearing twice, Jose. Sorry, I'm sure that's one I've forgotten. But look, thanks for everything. Thanks to you all. Any final thoughts before we close, guys? No? Okay, in which case I will close it. Look, thank you to you in the audience. We will be posting a video of this on the Legal 500's website, subject to edits and approvals, but pleasure. Thanks, guys. Bye.
Thank you. Thank you.
Thanks, everyone.